This is a special report from True Crime Today and the Hidden Killers Podcast.
From the Hidden Killers Podcast, I'm Stacey Cole. Brian Kohberger was back in court for a hearing on a potential change of venue for his capital murder trial. Let's go now to the courtroom.
Sorry for the disruption about that, but we're going forward now. Okay. Ms. Taylor?
Thank you. Your Honor, may I attempt to share my screen?
Yes.
All right, Dr. Edelman, let's talk about community attitude survey. What is that?
Well, it's a survey designed to estimate opinions and experiences in greater populations, which in this case are the prospective jurors in Latah County.
Is there a specific way you set up to do a survey?
Yes, of course.
Can you tell us about it?
Sure. So a lot of the design and structure of these surveys is based on some of the guidelines, professional guidelines from APOR, which is the American Association of Public Opinion Research, and the ASTC, which is the American Society of Trial Consultants, and also 40 years of people doing this. So the way it works is we randomly select people through a random digit dialing approach. So it's a probability sample. Everybody has a known chance of being included. And the first section is a screener to assess to make sure people are jury eligible. So they have to live in the county, have a driver's license, or be registered to vote, be 18 and over, and so on. And then they're introduced to the survey. There's an introduction actually at the beginning, even before they answer a question, or they're told why they're being called, or calling to get their opinions about an upcoming trial, and that their opinions are important because they were selected as a representative, household or whatever in the community. And then after they go through that screening process, they're instructed that there's no right or wrong answers to any of the questions. They can always report that they have no opinion or they don't know, and everything will remain anonymous. So the first few questions try measures just basic criminal justice attitudes to get them familiar with the process, familiar with the survey, answering questions. And then they're introduced to the actual case, so they're read a case recognition question. And then if they know about the case, they continue and are asked prejudgment questions, open-ended questions to assess some key opinions, then case knowledge questions, which are recognition questions. And then they go into the demographic section, which is how they consume media. And yeah.
You mentioned two organizations, and I think earlier you mentioned that you were regularly a member of those organizations. Do they help set standards for how surveys should take place?
They do.
And tell me a little bit more about the introduction. Why do you do that?
The first introduction or the instruction after that? They get through the screener.
The introduction and then the instruction.
Yeah, well, you're trying to encourage people to participate to increase response rates, right? So you're told, again, why you're calling. It's not a sales call. We're calling to get the opinions of people in your community and why. So it's not just random, so they understand it's about an upcoming trial. We don't tell them what trial because that would clearly lead to potential response bias. And they're encouraged to continue participating because they represent their community. They were selected randomly. And then there's efforts to increase response rates by we do callbacks. So everybody, each number is called up to 3 times at different times of the day. So if somebody maybe is at work, you still have a chance of being included in the survey. There's soft conversion techniques. So if somebody's kind of on the fence, like maybe they're like, maybe I'm busy, can you call me back? We try to find out when can we call you back so we can talk to them later, just to encourage them to participate and not drop off. So all of that stuff is done to increase response rates as best we can. And that's all starts with the introduction. And then the follow-up introduction or instruction kind of is similar. It explains there's no right or wrong answers. They're not forced to say yes or no. They can say no opinion, I don't know. They can refuse to answer the question, all of those things.
Can they answer some questions and not others if that's what they want to do?
Absolutely. That's called a refusal. So they might say, I don't feel comfortable answering that question, or I'm not going to answer that.
All right. So you did a community attitude survey in this case. Did you only look at Latah County?
No.
What counties did you look at?
So we looked at 4 different counties overall. So we looked at Ada County, Bannock County, Canyon County, and Latah County.
I'm going to talk to you a little bit later about the 3 comparative counties. But for now, can you walk us through your high-level findings for Latah County and Ada County?
Sure. So I think high level, you can see case recognition is very high. And it's also high in Ada County. It's 93% there. It's almost everyone in Latah County, 98%, which is similar to what I saw in the George Floyd case, where it was 99%. So this is extremely high. They're pretty much the same. And it's not just a passing familiarity with the case. It's not that they recognize it but don't know much. You can see people in Latah County reported that they followed the case somewhat or very closely. Almost 70% are closely following this case. And again, that means they're actively looking for information, passively consuming information, talking about it. So it's a big deal in this community. And there's a presumption of guilt. The burden has shifted. So 67% believe Brian Kohberger is guilty of murder, and 25% reported that he's definitely guilty. So these are strong opinions. And 51% reported what I call a fixed opinion, where they reported that Kohberger would have a difficult time convincing them that he's not guilty. So the burden of proof is shifted on the defendant to prove his innocence. And that's undermines due process. That's not how our system is designed to work. And also on the question of sentence, you can see that 52% believe that he should be sentenced to death.
When I look at this slide and I look at the prejudgment, I'm guilty of murder, and I'm using that term right, prejudgment means somebody's decided before we ever get anywhere near trial that Mr. Kohberger is guilty of murder. When I look at those numbers, it's higher in Ada County. And it's not a secret to anybody in this room that our argument is to move this case to Ada County. Does this seem counterintuitive when I look at the prejudgment rate and it's higher percentage-wise in Ada County?
Yeah, so first of all, in my mind, it's 2 questions. One is, should the case be moved? Not where. It's should the case be moved? Has presumption of innocence been undermined based on the reasonable likelihood standard, which is less than the preponderance of the evidence? So the second question is where? In a case like this, you're going to see high case recognition and high prejudgment everywhere. They're essentially the same in terms of 67% to 68%. But when you look at case recognition and size, population size, you'll find that in Ada County, there's about 16 times more people in that county that have not prejudged, if you do the math. So yes, those numbers look the same for those who recognize the case, but there's a much larger swath of people who haven't prejudged. And it's not just prejudgment that matters. So that's one variable you look at, but it's not just that. There's a host of other things. Extent of case knowledge, connections to the case, been exposed to rumors. There's all these other factors that play in. It's not just one item. It's the totality of the findings, not just one question.
When I move to the other slide, what am I seeing on this slide?
So these are instances just to show how invested people in this community are. So almost 80%, 79% have talked about this case online or in person. And that's where information is spread. So even those who may not closely follow the news are learning about it from their neighbors, from their coworkers, from family, from social media, and all of that. So information is being spread through those channels as well. And you do see big differences there when you're looking at Ada County. It's much lower because they're less invested in this case. It wasn't a shocking incident that occurred in their own community. You see that 32% have watched a show, for example, that Netflix or Paramount show or Dateline or something about the case. Almost 40%, 39% personally experienced high levels of stress, anxiety, or fear during the search for the killer while they were here. So that's very high. And then 45% know someone else who has. And if you look at those together, it's actually about 63% have either personally experienced fear or know someone who has during that search. And that shows like the impact it had on them. And you'll see it later in some of the opens where people talk about I was scared to walk outside or running to their car from work because they don't feel safe. They can see the house from their office. One person mentions that their wife was scared to go to the supermarket. People talk about they locked their doors for the first time. So it just shows the personal fear and impact this case created in this community that you do not see in large communities.
I have a follow-up question for you on this slide. The statistics that you show us show that the incident of looking at things on social media and Netflix and regular primetime news shows is higher in Latah County. And that correlates to the sampling of things you showed us a few moments ago, just your sample of what's out there on social media, on Netflix, and that sort of thing. Is that right? It's higher in Latah County?
It is higher in Latah County. Now, when you say correlates, like I didn't do a statistical analysis, I would say that's the stuff, the content out there. That's what it looks like if you just do a search and you're following it. And on the anxiety question, that number for Ada County is about 32%. So it's much lower.
Looking at this slide, what does it mean with these differences we're seeing in numbers?
Well, to me, again, it shows personal connection, the personal experience. In a big county, there might be a sensational crime, but you don't see people feeling that way. Because crime is unfortunately frequent, and there might be something else that captures their attention, or there's so much going on. It's not shocking. Here, this is something when people talk about, again, there's an idyllic community where everyone felt safe, and this person took it away from us. It was like shattering this sense of security and safety that we have. And everybody experienced it. And my guess is a lot of people can probably reflect on where they were when they learned this and how it impacted them personally. So it's very unique.
What are we looking at on this slide?
I think you skipped a slide. Yeah.
Okay.
Is this one that starts with lived or know someone who would?
Yes.
Okay. So again, this comes back to personal connections. So 78% of survey respondents either lived or know someone who lived in Moscow when the murders occurred, compared to 20% in Ada County. And that's not surprising because if you look at the size of Latah County, it's about 32,500 people over the age of 18 compared to about 406,000 in Ada County. And I think it's like 66% of Latah County is in Moscow, so it's a huge percentage. So it's not shocking that people were here or know somebody who was here when it occurred. And a large number of people are students or employees of the university. It's a quarter of the sample. I ran across one citation where it was like 36%, so it's even higher. Much lower in Ada County. And you can see 40% of people have visited a home or walked by it where this crime occurred. And again, if you look at some of the opens, somebody talks about seeing the house from their office window. So it's a constant reminder of this awful thing that happened. These are things, again, that jurors coming into that courtroom will see. It's like indicators in the community of what impacted them. People may be fearful of people know they're on the jury and all those things because it's such a small community and people are so invested. And you can see that 22% of the respondents actually work or know someone who worked for a law enforcement agency involved in the investigation. 22% compared to just 4% in Ada County. So again, direct connections to this case.
And those direct connections, those are things that a Latah County juror would bring in. Is that right?
Yes, and that's where we see these big differences in national cases like this. This is typically what you see when the entire state is saturated with coverage. Everybody's going to know about it and have opinions to some degree, but it doesn't necessarily have personal connection. That's why cases like the Oklahoma City bombing case was moved. I mean, that was a national case. Everybody knew about it, but they still moved it because of the personal connections.
And now advance to the slide. What are we seeing on this slide?
Well, this goes back to case knowledge. So we talked earlier in the day about how case knowledge and it impacts prejudgment and how we have this belief perseverance. So people develop these more complex schema and case knowledge. They're more resistant to change. And you can see almost 80% of people in Latah County were familiar with at least 5 of the 9 media items we tested in the survey, almost 80%, and 52% knew 7 out of the 9, or at least 7 of those items. So they have a lot of case knowledge here. It's quite high.
While we're here, I'm talking about the media items. Did you test on every media item you could find?
No.
Did you have to select a certain number so that you could do the survey?
What I do is I read all of the media coverage that is local, those local newspapers, and I'm pulling items that stand out, that are repeated quite a bit. So there's like multiple references to certain things and things that are inadmissible, prejudicial, things that are likely to create bias and have an impact.
All right. I want to talk a little bit more about how you set up the survey. What are we seeing?
So this should kind of give you an indication of the flow of the survey. So this is what I call the case recognition question. And it's developed by reading a lot of the coverage and seeing how the case is commonly described in the language in the newspaper and TV to construct a case recognition item to try to trigger a memory. So if someone answers yes to this question, question 2A, they then go to the prejudgment question. If somebody answers no, we give them a little more information to see if that triggers a memory. If that does trigger a memory, then they go to the prejudgment question. And if not, they go to the demographic question. So we always have 2 case recognition questions. That's a recommendation, again, in the ASTC professional guidelines. We usually pick up 1% to 2% when we do that in most surveys.
Does this question come after your earlier questions to get them to take your survey, the introduction and information questions?
Yes, it's actually even deeper. So you get the introduction. First you get why we're calling, and then you go through screen of questions, and then you're given an instruction about you. There's no right or wrong answers. You can always say, I don't know. I can always refuse. Your answers are anonymous. Then they answer, I think, 3 or 4 general criminal justice questions, and then they get to this question.
When you say the prejudgment question, are you talking about the media items stuff? Is that the same thing you're talking about?
Prejudgment is whether or not you believe a defendant's guilty of whatever the crime is. This is before any of the media items. You would never put those media items and then ask if you think they're guilty, because then you'll create response effects. Like maybe they didn't know that item and you just gave them prejudicial information, and now I think he's guilty because you just told me he confessed, or whatever thing it is. Like, you wouldn't want to do that.
Is that why the survey is designed that way?
Yes.
All right, let's talk about some of the survey results. Walk us through what we're seeing there.
Okay, so again, the data suggests that this case has captured the community's attention. This is not a case where people have moved on. Almost everyone in the community recognizes this case. You're at 98% recognition rate. And it's not just a passing familiarity. People are closely following the case. 29% are following it very closely. 39% are following it somewhat closely. So you're basically at 60% closely following this case, which is quite high.
All right. What are we seeing on this slide?
So this is one of the ways we test the validity of our survey. So we talked again, when we talk about the research, we know that people who closely follow a case, people who have a lot of case knowledge, are more likely to believe a defendant is guilty. So one of the things we would expect is to find a similar relationship in our survey, which indicates validity. So, and that's what we find. So whether or not people are closely following this case is significantly related to bias. So if people are following it very closely, within that group, the guilt rate is 84%, and somewhat closely it's 73%. Just kind of looking at it combined, you're at basically 77% of people who are following it somewhat or very closely believe the defendant is guilty of murder. So the more you follow it, the more likely you're to be exposed to prejudicial content, the more likely you are to develop a complex memory and case knowledge, and more likely to have an opinion.
All right. What did you learn about prospective jurors who are talking to each other?
So one is the fact they are talking to each other, and we don't always see that. Sometimes that's 40%, 50%, or even less in terms of talking about a specific case. And you can see here, it's almost everyone. 88% of people who know about the case have talked about it either in person or online. That's quite high. And they're following it, seeing things on social media. They're watching, Netflix episodes or Paramount or whatever it was on. They're seeing shows. They're seeing it in their news feeds. They're closely talking about it. In a small community, that's how information gets spread. It's what we call this informal communication network.
Did you have an opportunity in your survey to learn more about different rumors and things that are going around in Latah County?
I did. So we asked an open-ended question after the prejudgment question, and then it should be what they know about the case and their opinion. And we asked what rumors or theories they've heard in the community to see if they're regurgitating some of the stuff that's been in the newspaper, on social media, the idea, again, of informal communication networks. And smaller communities, you tend to get a lot of like, well, I knew somebody who knew this person, or personal connections, and information gets spread that way. And that's what we saw here. There's a lot of references to things that, the defendant committed a murder in Oregon, like speculation, no evidence of that. It's just something they heard, that he talked about committing the perfect murder on a paper, or that he hates women and he had trouble at the university he goes to with women, and people who worked with him had problems. He stalked her because she didn't respond to him. People were looking at Reddit comments or Reddit posts he had made and from years back, all that kind of stuff. And then references to him, having obsession with some of the victims, ritual animal killings. And these are just a couple examples. Like, you'll see that stuff everywhere, but the amount you see in Latah County is much higher. Like, if you go through comments in Ada County, you'll find some too. You can find examples, and I'm sure if you go to Bannock and Canyon, you're going to see them because the case has gotten so much attention, but not to the degree you have here. And given the size of the community, it's much more significant.
Did you record and document all of these comments in the actual survey report?
Yes.
Okay. And that's something that we provided to the court, and the state has no objection, so the court can read the full scope of the rumors from Latah County residents on his own time, I guess.
Yes.
Thank you.
Some fun light reading. You can read all those.
All right. What did you learn about Latah County residents that were related to Moscow, specific Moscow connections?
Well, this is kind of the unique nature of this too, that I see in cases like natural disasters, like wildfires is a good example, where it's this like collective trauma everybody goes through. So you can see 76% of residents here lived or knew someone who lived in Moscow at the time of the murders. So they either are here, the loved one is here, and it creates anxiety, right? So I think it was like almost 40% of students left during Thanksgiving, didn't come back because they were scared for their safety. And you see that in the other questions. So asking about if people experience stress, anxiety, or fear during that search, and you can see 39% reported that they personally did, and another 45% reported that someone they know. And if you look at those, it's called a crosstab, and the question is, did you or someone you know? It jumps up to 63%. So a large percentage of people were anxious and scared about their own personal safety or the safety of someone they know and care about.
Tell me about the open question about people's sense of security. Did people respond to that?
So one of the questions we ask is, how did this crime impact your community? And if I do this in a big county and I ask this, or big venue, federal case, you get a lot of, it didn't, or not much, or, I didn't live near it, so not me, or something like that. You get a lot of that. And I'm sure there's some of that here too. If you look at different things, Ada County probably has a lot of that, and Bannock. What really stood out to me was this shattering our sense of innocence, right? This is an innocent town, and no crimes or horrible things ever happened here. And this guy took it away from us. We had this idyllic, safe community, and this person destroyed it. This crime destroyed it. And they talk about people, they never locked their cars before, their homes. I think one person said, he didn't even have a house to his key when he bought it, or a key to his house. That makes more sense. And suddenly people are locking doors because they're fearful. People are scared to go to their cars. Again, someone mentioned, you could see the house from their office, and students and staff would run to their car to be safe. People's partners were scared to go to the grocery store. And there were tons of comments about that. This idea that we have this safe community and it's never going to be the same. It's lost. It's like our sense of safety and security, this special place, this tiny little place that's a bubble from all the bad stuff in the world. And then this thing happened.
The comments that you've depicted in this slide, is that all of them, or are there others for the court to take a look at?
There's plenty. On top of reading the other stuff, feel free to read all those opens.
Okay. What about the connection to the house where this happened? What did we learn?
Well, I think it comes to this direct and indirect connections to this case, which makes it unique in Latah County, which you don't see it everywhere. Is 40% of residents who know about the case, which is pretty much everyone, have either visited the home where the crime occurred or walked by it. And so there is this constant reminder of this awful thing in their daily lives. And also you see a large percentage of people are students or employees at the university or connected to it, the investigation itself. 22% were connected to the criminal investigation. And then 25% were either students or employees at the university. And we know, if you look at it, the university is a big employer in this community. And when all of these students leave, it has an impact on the economy. Over 60% of the county is made up of people who live in Moscow. And if you look at some of the data, it indicates about 36% of people in this county are either students or employees at the university. So even higher than we saw in the survey.
All right. I want to talk about the prejudgment question. What did you learn?
So this question is one of the indicators of undermining the presumption of innocence. So I look at it, I'm always looking, when I think about due process, is the presumption of innocence. And you see when it shifts to a presumption of guilt. So in this case, 67% of prospective jurors who recognize the case believe Brian Kohberger is guilty of murder, and 25% have a strong opinion on that. So if you think about it, given the high recognition rate here, if 100 jurors walked into this room during voir dire, 66% of them already think he's guilty before they've heard any evidence.
And that's just the prejudgment question. That's not talking about the other factors that you talked about, media awareness, case connection to the community, things like that.
No, that's just looking at everyone. And if you start looking at things like, well, do they know a lot of detail? That prejudgment jumps up to over 80%. Do they closely follow it? Jumps up to 70%, whatever it is. So that's just looking at the entire set. You start looking at other things, that prejudgment gets even higher.
You talked about what you defined as a fixed opinion or a fixed presumption of guilt. What did you find about that?
Yes. So the question I ask is basically based off, I'm going to start talking selective now. Based off of what you've read, seen, or heard, would the defendant have a difficult time convincing you that he's not guilty? So burden of proof shifting on the defendant. I think I mentioned this last time, but that question was developed by a judge in Tennessee. And what you were seeing was they would ask jurors, well, what do you know about the case? And they would tell them some information or minimize what they know. And then the question was, do you think he's guilty? And maybe they'd say yes. And then they'd say, but I can be fair and impartial. I can set it aside. I think I can do it. And then the follow-up was, well, would he have a difficult time convincing that he's not guilty? And they, oh, yeah, I can't change my mind. So it's just much more effective. I find it's more likely to be correlated with these other indicators of bias. So it seems to be more of a valid question. And when I did it, you see basically 51% indicated a strong opinion that would shift the burden of proof onto the defendant. And again, if you look at our analysis of 100 jurors walking in, that would be 50 out of 100 would fall into that category.
They can't change their mind.
Well, I'm sure you can get them to say they can be fair because I see it all the time. But this doesn't mean they can't. We heard a lot about that earlier today. Yeah.
All right. And did you ask similar questions, prejudgment for guilt, I guess prejudgment for the sentence?
Yeah. So because this is a capital case, I did ask whether or not which sentence do they believe the jury should select if he's convicted. And you can see 52% reported that he should get the death penalty based off of what they've read, seen, or heard, whereas just 23.5 or 24% reported that he should get life.
Did you ask a fixed question about the penalty?
Yeah, so I asked the same fixed opinion question, and you find that 51% believe that the sentence should be death and that he couldn't convince them that it should be life. Only 19% reported that the defendant would not have a difficult time convincing them that he should get a life sentence.
This is a small community. What did you learn about the impact of this case on this small community and the pressure of a juror in Latah County to do this?
So one of the things I wanted to look at, because it's a small community and people know everyone, and the pressure when you're coming in and out of this courthouse on a day-to-day basis, when it's been inundated with journalists, and my guess is people can figure out who's on the jury by who's not picking their kids up at school and talking to neighbors and all that. Is there pressure? Do the jurors ever feel pressure like there has to be a certain outcome? How would the community react if he's not convicted, if he's found not guilty? And there was quite a bit of strong comments and a range of themes from people would basically kill him to they burn the courthouse down or assume that the jury failed or that he would have to prove that he was not guilty. Again, shifting the burden. So it's like, I can't imagine that happening because they have so much evidence against him. We would be dumbfounded. Like, how could he not be guilty given the amount of evidence? Several would be on the hunt for him to make sure he gets what's coming to him. And then just emotional stuff about it would be devastating to the community. Other people talked about the fear if he didn't do it. Well, who did? Like, that means this person's still among us, who creates the same stress and fear and anxiety that people had before. So this community needs closure. And you have to imagine what that's like for a jury for months on end, coming in and out of this courtroom in this tiny community and trying to explain to their neighbors, what they did and why. And that shifts the burden again back onto the defendants.
The comments that you've captured in this PowerPoint slide, is this all?
Yeah, these are just a few examples.
Plenty more for the court to read?
Yeah.
Did you ask these open questions in the comparative counties too?
Yes, it's the same question as in all the counties.
Were the other counties as high of rate in these kinds of answers? Did they have a similar kind of answer as Latah County potential jurors did?
No. And now you can read through it and you will find answers that people would be angry and upset because you're talking to hundreds of people and you're going to get those. But they're much less strong. They're much more, no opinion. They wouldn't have an effect, things like that you see in other places. Very few people in Latah County have that thing.
All right. I think we have a couple of slides on the questions that were in the survey. I think we know those.
Yes. So these are our case recognition questions, we call them, or I call them recognition items, I guess. So we do ask an open-ended question. What have you read, seen, or heard about the case? We'll get into that, but that's the typical question you ask in jury selection. And people answer that, but they often use minimization language or unable to recall everything from it. So we ask later on these case recognition items to see if they're familiar with widely reported media items. And if you look at the professional guidelines, this is what's recommended. So we first ask an open-ended question, and then later we follow up with these closed-ended questions.
What did you learn when you did that in this survey with Latah County?
So I'm not going to go through all of them, but we learned that people are familiar with many items that have been widely reported in the media. And you don't always see that. Sometimes case recognition is high, but people don't know a lot of detail. Maybe they know a few items or recognition rates are 40, 50%. But what we found here are people have well-developed attitudes and opinions and have been recall a lot of prejudicial content. So in Latah County, you can see that 79% were familiar with at least 5 of the 9 media items, and 52% knew 7 or more of the media items that we tested, over half.
And you tested on 9, is that right? 9.
Yeah, up to 9.
And I think you mentioned, but I think your chart's going to explain to me why more media items, more media recognition items correlate with the prejudgment question of guilt.
Yeah, and this goes back to validity of the survey. Right? We know from earlier research that case knowledge is correlated with prejudgment, and that's exactly what we found. So the more people know, the more case knowledge, the stronger their opinions, the more likely they are to have developed a perception of guilt. So people who were familiar with 5 or 6 items, you can see it's 66% guilt rate, and for 7, it's 82%. So jumps up quite a bit. So the more case knowledge you have, the more likely you are to believe guilty. And you see the same thing with that, I call it that fixed opinion question. That's significantly related to case knowledge as well. So the number of people who said that he would have a difficult time changing their mind is essentially 66%. If they know 7 or more items.
Let's talk about the specific items that were known, just a few of them. We won't go through all of them. What did you learn?
So these are just going through a few that we tested, and you can see high recognition rates and significantly related to prejudgment. So whether or not people know that a knife sheath was found on the bed next to one of the victims, 81% of survey respondents in Latah County knew that detail. And you can see it's significantly related to bias. So if you knew that, 72% of people who knew that item believe he's guilty, and 55% reported that he would have a difficult time convincing them otherwise.
What about another media item?
What about what?
Another media item?
Thank you.
So the next one is whether or not they knew that DNA was found on the knife sheath, that there was a match for the defendant. And you can see that 67% know that detail. And if you know it, it's highly prejudicial. So 75% of people who know that item believe that he's guilty, and 60% reported a fixed opinion.
How about a vehicle recording?
So this one, whether or not Brian Kohberger owns the same type of car recorded on the video driving in the neighborhood where the killings occurred. This was a widely reported media item. So 86% of people know that detail. And 82% of those who do know that believe he's guilty. Quite high.
How about the cell phone tower media item?
So on that one, you see a case recognition rate or item recognition rate of 79%. 79% of survey respondents do that detail. And if you knew that, 72% of them believe that the defendant's guilty.
How about the media item studies?
So this would go down to like a misinformation, I'll call it an inaccurate detail that was widely reported, that the defendant had stalked one of the victims. And you can see recognition rate currently at 45% when the survey was done. And 81% of people who knew that detail reported that he's guilty.
How about following on social media?
I believe this is the last one. You can see whether or not he was essentially following them on social media. 45% recognition rate, and 79% of those who know that believe he's guilty. And these are all statistically significant findings.
Let's talk about some of the comparative counties that you surveyed, and if you can give me a high level of your key findings in those counties.
Sure. So now, in my mind, this shows significant bias, that there's a reasonable likelihood that the due process has been undermined in the sense that there's a presumption of guilt in this county. And the question is, if you were to move it, where would you move it? That's question 2.
We're on to the second part.
We're on to the second part now. That's where this comes into play. So you'll see recognition rates are high in these 3 counties we tested. So we tested Ada County because it's the biggest county in the state. It's about 406,000 people over the age of 18, and other high-profile cases have been moved there before and recently. Canyon County we picked because I believe it's the second largest county, and it is also near Ada County. So it's a big county. We picked that. And we picked Bannock County because it's just far away. And it had less media coverage. So we wanted to see if there was a possibility that people would have less case knowledge there. And you can see recognition rates vary from 90% to, from 84% to 93% across those 3 cases. And you can see that in terms of how closely they followed it is less than we saw in Latah County. So Ada is 58, Canyon is 51, and Bannock is 46. Compared to Latah County, remember, it was 68%, much higher. The guilt rates are essentially the same, or it's a little higher in Bannock County. But because of the population size, there's a big difference. So again, you'll find about 16 times more people in Ada County who have not prejudged compared to here. And then similar in terms of the strength of opinion and difficulty in convincing them that he's not guilty, similar to what you see here. and sentence similar as well. So you're in the 49 to 57%. So these numbers are also high.
Where do you start to see differences that matter?
You start to see differences when you talk about personal connection. That's where the big differences come up. So remember we said that 79% of people in Ada County had talked about this case. Might be wrong. Might have been higher. It's just 60% in Ada County, 50% in Canyon, and 51% in Bannock. So it's much lower. You'll see whether or not they've experienced high levels of stress. In Ada County, it's just 17%, and the other two counties, it's only 11%. It was 39% in the county here. And then whether or not they know someone who experienced higher levels of stress, we had 45% here. Here we're down to 24, 19, and 19. So you see big differences there in terms of the community connection, the personal connection for the case.
What about the connections to Moscow that are unique to this area?
Yes, so just 20% in Ada County know someone who lived in Moscow, 15% in Canyon, and 16% in Bannock, 78% in Latah County. Whether or not they were a student or employee in Latah County, that was 25%, and we're looking at 4% and 3%, much lower. Whether they visited the home or saw it, Latah County is 40%. Here we're down to 8%, 3%, 2%, much lower. Whether or not they knew someone who actually was involved in the investigation, in Latah County, that number was 22%, I believe. And in Ada County, it's just 4, Canyon is 2, Bannock is 2. So much lower when it comes to those type of connections, the personal connection, personal investment in the case.
What about the recognition of media items?
Yeah, so we had, I think it was 79% in Latah County knew at least 5 of those media items, and it drops to 65% in Ada, 52% in Canyon, 59% in Bannock. If they knew 7 or more, that was 52% in Latah County. It's just 42% in Ada, 27% in Canyon, and 29% in Bannock. So less case knowledge. And we know case knowledge comes back to belief perseverance, right? So the more you know, the more resistant your attitudes are to change, the more likely you are to attend to and process information consistent with what we know. New information about the DNA evidence, I already know about that. That's credible. I give that weight. So you're much more likely to see that in Latah County. Be sure.
All right. I think you told us a little bit about the population size. And is that why you selected Ada was the population size?
So I'm not selecting anything. I'm just pointing out some possibilities. So I selected Ada County in terms of to do the survey because it's the largest county in the state. And, you know, I think it was a demo case was moved there. So you know that they can take this case in. We know large counties, it's less of a big deal when the case moves there. It doesn't become the biggest story in that community. So I wanted to test Latah County. Pick Canyon because it's the second largest county, over 184,000 people. And then I picked Bannock because it's further away. It's quite far away, hundreds of miles from here, and it's in a different media zone. It does have some of the similarities of Latah County. So, for example, there's a university there that's the second largest employer. So there's a risk there. But 18% of the population is connected to that university. So there are those risks. And I think the problem there, while some of the numbers are good, it'll become a huge deal if that case is moved there. You're gonna have the media circus move from here to there, and it's gonna become, again, a huge story in that community. So there is risk if you choose a smaller venue that something like that will happen.
And that risk is tied specifically to the size of Bannock County?
Yes. Smaller counties, you don't have stories like this regularly happening. So it's more likely to become a big deal in that county. And you could end up with significant bias between the time the case is moved and the time it goes to trial, because there might be an increase in media coverage there.
When we talk about the survey itself, was it only people who knew about the case that took the survey?
No. Explain to me what you mean by that.
Well, I'm looking at your slide here about people who, whether or not they know about the case, do they finish the survey? I think one of the things the state's criticized about is a non-response bias. So I want to understand if you can tell if that about how the survey works, this one and others.
Right. So first of all, one thing we do is we do comparison surveys in a host of different cases. So if you look at other cases we've done this on, if that were true, you would find that only people who know about the case take the survey in the comparison count as well, right? So you can see in Renfro, this was an Idaho case, in Kootenai County, 89% of survey respondents recognized the case that took the survey, that completed it. In Ada County, 67% of the people that completed the survey did not know about the case. So you would expect that you wouldn't see that trend if people just say, oh, I don't know about this, I'm not going to take the survey, I have no opinion. In state of Tennessee v. Andrew Delkey, similar findings. So in Davidson County, 67% of the people who completed the survey knew about the case. In Hamilton County, 84% of people who completed the survey did not know anything about the case. In United States v. James Cloud, which was in Washington, you can look at, we did 3 venues, and in Yakima, 55% of the people that completed the survey knew about the case. In Richland, 82% did not know about the case. In Spokane, 90% did not know about the case. What's unique and why you see high recognition rates across the surveys here is because it's a national case. And when we have national cases, you see high recognition rates all over. So this last one, the state of Minnesota v. Alexander King, was the George Floyd case. And you can see high recognition rates in all the counties, just like we see here. The reason is because there's a lot of media exposure everywhere. But it's not that people are hanging up because they don't want to take the survey. In fact, if you look at the call data, after they were told the case recognition question and described the case, only one person hung up out of the 1,200 people that completed the survey. We had one person who terminated the survey after being told what the survey was about. Everyone else.
All 4 counties?
All 4 counties, one person.
That's all right. We have talked quite a bit about the bias and the prejudicial media coverage and the difficulty, the impossibility that will happen seating a jury in Latah County. I want to talk a little bit about jury selection in cases that have a lot of publicity. Are you familiar with that?
Sure, yes.
All right. Why should we talk about this now? Why do we not want to just wait and try to pick a jury first?
Well, I think first of all, I've done a lot of jury selections. I'm sure you have, Your Honor, you have, I'm sure you all have. So we all know how the jury selection process works. So in a normal case, people do not have case-specific attitudes. And we know specific attitudes are predictive of behavior. So I might just have a general passing attitude towards something. I mentioned DUI, or it's like a contract dispute. Like, you can ask me questions. I don't have strong opinions. I don't know anything about the case. So they're not specific attitudes. So jury selection is effective in that scenario. It's fine. But when people have case-specific attitudes and case-specific knowledge, and I've heard information and evidence, even if it's coming into trial, I've heard it in the context of a news story. There's no rules of evidence that were applied. There was no cross-examination. There was no counter expert to refute what was said. It was just said by a public, speaker. It was on an editorial on a television station, on Nancy Grace. So it's very different. And then when I hear it as evidence, it's just confirming what I already know. It's not new, not processing it for the first time. So that's one of the big problems. So why you need to identify people that have that content and information. And there's challenges because of the way memory works. Recall is limited, and we'll get to that. But when you ask people, what do you know about the case? They are not able to give a full account of everything they know. So it's very hard to assess what people know, which makes it very difficult to exercise cause challenges and predicate challenges. And the other thing is just the nature of jury selection. It's very easy to rehabilitate a juror to get them to say they can be fair. It happens all the time. So a juror says that I had this experience, or I think I'm leaning towards one side, and it's so easy. We do it all the time to get a socially desirable response. You start with, well, the law requires everyone to be fair. Everybody has their own opinions, and that's okay. We're just asking you, can you follow the law? Can you follow the instructions? Can you deliberate? Can you be fair? And most people will say yes to that because they want to create a socially desirable response. They know what the right answer is. Give leading questions. In one study, they actually analyzed a transcript or 3 trials transcripts, and it was like 60% of the comments during voir dire were from attorneys and judges. Just 40% were from jurors, and 63% of the comments from jurors were one-word answers. And I see that in the post-conviction stuff I do when I analyze transcripts. It's 3 pages of indoctrination into what a juror is supposed to do, ending with a closed-ended answer, can you set it aside? That's not an indicator of their ability to do. People can't just men in black flash heaping themselves and forget everything. It doesn't work that way.
I think we may have covered voir dire and honest disclosure with that, and I didn't advance the slide. Can you give us a case example or an example of this?
Sure. So this is an example of stealth juror. So a case like this, you're a stealth juror, there's a likelihood that people want to be on this case, right? It's a high-profile case. It's going to be on TV. It's going to get a lot of attention. There might be a desire to see justice, and you want to be involved in that. Well, how do you identify jurors like that? So this is an example case I worked on where it was a long time ago. It was in LA. There was this division in the police department called the Rampart Division. And basically, there were a number of corrupt police officers who were stealing drugs out of the evidence locker, shooting suspects and planting guns on them. It was these rogue police officers. And one of the people, his last name was Ovando, he had been shot by a police officer, this guy Perez, who then planted a gun on him and alleged that Ovando had shot at him. So he was convicted of attempted murder. He was paralyzed from the waist down. And then Perez got caught stealing drugs out of a locker room. So he confessed to all these things, and Ovando was released. He got like a $20 million settlement against Latah County. Then he sued the public defender, claiming that, they should have figured this whole thing out and known that, there was a scandal and so on. And it won like $6 million in that case. And then later, when they looked, it turned out that one of the jurors on that case had been in a movie about the incident called Gang Wars. And when they were asked, has anybody have a connection to the case? She didn't raise her hand. But during the deliberations, she talked about stuff she knew. She talked about stuff that didn't come into trial, and it resulted in a mistrial. So that's just one example. There's other examples as well. But yeah, so that's one challenge you have in a case like that.
All right. Recall and recognition. I think you're going to talk to us about how hard it is to ferret out what somebody knows.
So to me, this is one of the biggest challenges in high-profile cases. So the question you ask on a juror questionnaire and an open voir dire is, what have you read, seen, or heard about this case? That's the open-ended question you ask. That is what we call a recall question. And the cognitive task is, on the spot, I need to search my memory and see what's accessible and salient and what I can remember on the spot. And I'll tell you. And then you it's usually followed up with, can you be fair and impartial? And what we find is people are not able to recall everything they know. And that information that they forgot to mention comes up later. So the common example is, tell me everything you know about a movie. I'm going to go with Star Wars. And you probably will tell me a lot because a lot of people have seen that movie or seen it a bunch of times. But if I asked you follow-up closed-ended questions, you'd find that you forgot to mention a whole bunch of things. Maybe you didn't mention that Luke Skywalker was Darth Vader's son, right? And it was, do you remember that? Oh, of course I know that. I just forgot to mention it. So you see things like that. So the tricky thing is you can't ask people, have you read, seen, or heard if the defendant was stalking one of the victims? Because now you're poisoning the well. What if they didn't mention that and they're open-ended? Doesn't mean they don't know it, because we know about 45% of the population here does know it. So you're in that position where you are trying to make an assessment if this juror can truly be fair and impartial without knowing what this juror actually knows about the case. And that's one of the biggest problems you have in high-profile cases that are not a problem in your run-of-the-mill typical case.
Have you seen that bear itself out in a real case?
I have. This was a case in Texas where we actually had community members come in during the venue hearing, and treated them like mock jurors in a sense and asked them what they knew about the case. And they told us it was a big case at the time in Latah County in Texas. And people told us what they knew. And then we asked, is that everything you know? And they'd say, yes, that's it. And because it's not real jury selection, we had the opportunity to demonstrate this whole problem. And we would say things like, well, did you know that he allegedly confessed? And then it would stimulate a memory. And the person would say, oh, yeah, I did know that. He actually confessed twice at a monastery. So it triggered a memory. And then it was, well, is that everything else you know? Do you know anything else? And they'd say, no, that's it. And say, well, did you ever hear that he had committed another crime? And they say, oh, yeah, that's right. He actually attacked another girl at a different church in a nearby town. And it was, well, is that everything you know? Take your time, search your memory. That's it. And then we do it again. And it was, well, did you know there was a cover-up? Oh, yeah, the Catholic Church covered it up and the police department. And it just demonstrated the problem. Now, that was fine in that little demonstration we did. But you could never do that in jury selection, because if you did that, you just poison that juror. If they don't know it, you just poison them. If they did know it, then you have to get rid of them, right? So you're in this impossible position in terms of trying to figure out if this juror can be truly fair and impartial when you don't know what they know.
Do we have a glimpse of how that works in Brian Kohberger's case based on the search warrant?
We do.
All right. How do we know? Tell me about that.
So we always use the open-ended question. What have you seen or heard about the case, and code it? And what we found is, on average, people reported 1.6 details when asked that open-ended question. So we know that's the average number of details they report. And then we compare that to the closed-ended questions later, those 9 media items, to see if there's additional items that they actually recognized that they failed to mention in the open. And what we found in this case was that 96% of survey respondents knew at least one of these media items that they failed to mention in the open. And on average, they recognized an additional 4.9 media items. So almost 5 out of the 9 failed to mention. And these are just some examples. So, someone said, what have you seen or heard about this case? Just what has been on the TV and the papers. So that's minimization language. They use the word just. There's no specific detail. But later when we ask those closed-ended questions, that person knew all 9 of them. Another one is just what I've read and seen on the news and newspapers. Again, knew all 9. Read articles about the case. Knew 8 of the 9. Just what I read in the papers. Same as everyone else. 7 of the 9. So these are just a few examples, but this is what happens. This is what you see on juror questionnaires. This is what you see in voir dire. And I mentioned that, anyways.
And that's dangerous in this case because of the amount of prejudicial media coverage. Is that right?
It's dangerous in this case and in high-profile cases. That's the unique problem they create. What's unusual in this one is, 1, it's in a small community, and 2, people here have very well-developed schema and attitudes and case knowledge.
I think you have some specific examples of some of the media items tested about how many recognized an item that had not reported.
Yeah, so just to give it two examples to make the point. So this is the one we talked about, whether or not the defendant stalked one of the victims. Prejudicial, 45% of survey respondents recognized this item when we asked, have you read, seen, or heard it? But when we asked them the open-ended question, what have you read, seen, or heard about this case? Only 3% mentioned it on their own. So 3% of people reported this item, but 45% actually recognized it later on. And we know it's not only is it not true, but it's also prejudicial because 81% of people that know it have already judged the defendant as guilty. So it's really important to know who are the people in this panel that know that detail. So your choice is to just assume no one knows it because they didn't spontaneously mention it, or poison the well by asking the juror specifically, did you know that Brian Kohberger allegedly stalked the victim? So that's a difficult position to be in.
Let's look at one more example of how that worked.
So this is the one about the knife sheath, whether or not police found a knife sheath on the bed. So you probably want to know that. Well, 81% of people recognize that item later. but only 8% mentioned it when asked the open-ended question. So again, just demonstrating the problem. These are items that are correlated with bias. We know that there's a high rate of recognition in the community, but when you ask in jury selection, what have you read, seen, or heard about the case? Very few people mention it. This is what you see.
All right. The magic question, can you set it aside and be fair and impartial? Is that going to work?
I'm sorry, what's the question?
Is this going to work? This question.
Yeah. So you want to, what is this a good question, bad question?
Will it work? Will it help
Will
us?
it work? What does work mean? I don't know what you think about that.
Help us find an impartial jury.
No, there's no data to suggest that this is a valid question. And just touching on the research again, what you would expect is people that know a lot about the case or been exposed to prejudicial pretrial publicity would be more likely to say they cannot be fair and impartial compared to people that do not know a lot about the case. And there's no significant relationship. People who know a lot of detail and have been exposed to prejudicial pretrial publicity are just as likely to say they can be fair and impartial as people who have not. So there's no data to support that.
And do you have an example to tell us about?
So this is some research I did on this question to see how people respond to it. And so what I did was I went to a Facebook page that was about this documentary on HBO that got a lot of attention called The Jinx. The Jinx was about a person named Robert Durst who had been a suspect for multiple murders for his wife. He went to trial in Texas for murder, and then a good friend of his in California was killed, and he was suspected to be involved in that as well. What was unique, he was from a very wealthy family in New York, so it captured a lot of people's attention. And there was this mini-series on HBO. And at the end of it, they confront him with some evidence that would suggest he was involved with his friend Susan's murder. And he takes a break and he goes into the bathroom and he forgot that he was wearing a microphone, and he pretty much confesses. He says, "Of course I shot them all," or "Of course I killed them all." He's talking to himself. So it was a highly prejudicial documentary. And later on, he was charged with the murder of his friend. So what we did was we went to this Facebook page where people had made public statements about the defendant that were highly prejudicial. So this is just one example. Someone said, "This is a true version or vision of a sociopath. I'm physically ill over the conclusion. I'm beside myself. I was overjoyed at the news that he was arrested." So if somebody said this in public about this case, I think we'd all agree that person probably can't be fair. You're publicly stating it to the world. You think he's a sociopath. So we recruited people that made these extreme comments on this page and went through a survey. And we asked if they knew about the case, whether they thought he was guilty, what they knew, and so on. You can see, as you'd expect, almost everybody we recruited who made these public statements reported that Robert Durst was guilty of murder, 92%. And reported strong opinion. 77% of the people we recruited said that he could not change their mind about his guilt. So almost everyone. And then we asked those closed-ended case recognition questions, and many of these are either inadmissible or very prejudicial. That he was like a suspect in his wife's disappearance. Probably not admissible in a different case. His murder trial in Texas. We asked several of these. And the confession, the captured confession. You can see 100% knew that, which is considered like the most prejudicial thing that can be in the media, according to the Supreme Court. And so what we'd expect is that these people would say, "I cannot be fair and impartial." There's so much bias that they're demonstrating. So we give them the magic instruction that you often see. This came from a transcript in a high-profile case where the court had explained the burden of proof and that the defendant's entitled to a fair and impartial trial, and that the law requires that you set aside everything you know and only rely on the evidence. Common things you hear. And all these people who express all this public bias and all this vitriol and reported that he's guilty and you can't change your mind, by just saying that to them, magically report that they can be fair and impartial. 81% said they could be fair and impartial after hearing that instruction. And they gave open-ended responses as to why. So this is our participant who mentioned that they were overjoyed by his arrest and they were physically ill, and that Robert Just was a sociopath. Well, they, on a scale of yes, definitely to no, definitely not, they reported that they could definitely be fair and impartial. And they reported that I could start from the beginning and listen to all the information presented and follow the directions and wipe out everything that I know. I would need to be convinced beyond a shadow of a doubt. So that answer, if you see in a courtroom without knowing that this person was making public statements about the defendant being a sociopath, probably considered rehabilitated as a fair and impartial juror. But it demonstrates like a person like that should be answering that question, no, but they don't. And even kind of going back to the Rideau case, which was recorded confession in the police station with the chief of police on one side and officers on the next, played in the media with music on it. It was highly prejudicial in a small town, and the Supreme Court ruled that, threw out the conviction because of it. All the jurors in that case who saw that confession reported that they could be fair and impartial. They all sat on that trial. They all reported that they could be fair, and the Supreme Court didn't take that at face value because the content of the coverage was so prejudicial.
All right. Based on your years of experience, your education, all of the work that you do in general, and then specifically the work that you've done in this case, the survey, the hundreds of comments, do you have an opinion about this case and whether we can seat an impartial jury in Latah County?
I did.
What is your opinion?
So my opinion is based on whether or not there's a reasonable likelihood of using that standard, which is less than the preponderance of the evidence. Latah County is a small venue, and the crime has been seared in the community's consciousness. People have been saturated with prejudicial coverage. Many people here have direct and indirect connections to this crime. People here demonstrate that they experience fear and stress, panic in this community. There's significant rumors and misinformation that have been spread and people have been exposed to in this community. There's a feeling of pressure to convict, I think, given the reaction that people think the community would have if he's acquitted. That's particularly concerning. We know from the data that jurors have closely followed the case. They've talked about it. They're familiar with prejudicial details. I think that the presumption of innocence has been undermined and a presumption of guilt prevails in this community. And I think the pre-existing attitudes and opinions will influence how people process the evidence. So even if the same information is presented at trial, there's a big difference in terms of jurors being exposed to that for the first time. I don't know about the DNA evidence. I don't know about the videos versus a juror being exposed to something that they already know, where they're just confirming what they already know. I already know about the DNA evidence. It's just triggering a memory of what I already recall. And I'm processing this information through that filter of it's consistent with what I believe and I already know. And it impacts how they see government witnesses and how they will view and evaluate defense witnesses. And I don't think voir dire is an effective remedy given the research I've done, my experience doing jury selections, and the nature of how memory works. So taking all that combined, I think it's appropriate to change that.
Thank you. I don't have any other questions, Your Honor. And Dr. Edelman, hang tight if you should statement.
Okay, thank you, Ms. Taylor. So this would be a good time to take a break.
Sure.
And we'll come back at 3:20. Thank you. Dr. Edelman.
This has been a special report from True Crime Today and the Hidden Killers podcast.